Hi everyone, this is Pennsylvania attorney Evan Gutman presenting video number 4 of my video legal education series based upon my book titled State Bar Admissions and the Bootlegger's Son. The full book, along with a supplement I wrote years ago actually, is currently available on either of my websites at heavensadmissions.com or gutmanvaluations.com. Those websites also contain a fictional legal novel I wrote titled Heaven's Admissions Process, kind of comparing the criteria to be admitted into heaven with the criteria to receive a law license. The focus of my books, as well as this video series, is on the good moral character requirement to obtain a law license. I also address other controversial issues and areas of the legal profession and judiciary branch of government. So here we go with today's chapter. Today, I want to discuss why the state bar admissions process is even important. What does it matter? What is the importance of the state bar admissions process? For instance, let's take the following scenario. You've just been arrested and charged with some type of crime. You've just been a victim of some type of crime. One of your friends or family members has just been a victim of a crime or accused of a crime. You're going through a divorce. You're being sued by a creditor. You're late on child support payments, or you're not receiving child support payments that you're entitled to. Your house is being repossessed. You've been subpoenaed to testify as a witness. You've just been in a car accident. My gosh, you are really having one lousy day. But the fact of the matter is, anytime you're involved in anything that potentially involves litigation or a court proceeding, in all likelihood you will need a lawyer. So what type of person do you want to hire as your lawyer? Do you want someone whose primary interest is fighting on your behalf? Or do you want someone who's going to be more concerned about fostering and promoting the financial interests of other attorneys and the agency that licenses them, rather than zealously representing you? It's my guess the average non-attorney citizen's focus and concern with lawyers is singular in nature. They want someone who's going to zealously represent them. So that brings us now to the good moral character requirement again. I present the question again. What kind of lawyer do you want to represent you? If that is determined by who becomes lawyers. Thus, the state bar admissions process and its good moral character assessment ultimately affects any citizen who needs a lawyer one way or the other. If the state bar admissions process is designed from inception to subserviate non-attorney applicants and foster a fear and subservience within the licensed attorney, then their clients are not going to have zealous representation. If it's designed to, on the other hand, on the other opposite end of the spectrum, if it's designed to be too liberal by admitting convicted felons, clients will also suffer. If it's designed to place new young attorneys at a disadvantage compared to older attorneys who have better connections, then clients will suffer the ramifications of that also. If it is designed to exclude minorities from the licensing process based upon subjective assessment of good moral character, then non-attorney minorities will not be able to receive competent representation. If it is designed to glean out individuals who have, quote, bad attitudes, then citizens should expect that courts will adjudicate their cases based upon litigant attitudes instead of the facts, law, and evidence. That is why it is important for the bar admissions process to be objective, fair, and clearly defined. Currently, it is arbitrary, discretionary, capricious, and as correctly stated by the United States Supreme Court in the case of Koenigsberg versus State Bar of California in 1957, a, quote, dangerous instrument, unquote. More specifically, what the court wrote in the Koenigsberg case is as follows, and this is important. The term good moral character has long been used as a qualification for membership in the bar. However, the term by itself is unusually ambiguous. It can be defined in an almost unlimited number of ways, for any definition will necessarily reflect the attitudes, experiences, and prejudices of the definer. Such a vague qualification, which is easily adapted to fit personal views and predilections, can be a dangerous instrument for arbitrary and discriminatory denial of the right to practice law. That's what the U.S. Supreme Court wrote in Koenigsberg versus State Bar of California in 1957. So, hope you found today's presentation interesting. We'll see you in a day or a few days, hopefully. And remember, love right, don't fight. Bye.